My apologies, and we're going to have to, let me just go over and see, is this the summary. These are learning things, which I hate, but let me just check and see whether this is a, to summarize this, and you can go over any of the parts that you want to, but I'm very sorry for going on a bunch of things. And anyway, that my understanding is that you testified that SE Consulting Group you hired in 1998, and that he recently died, that he managed many associates, and you understood him to have a contract, but you didn't know. And when you left, that that the waterworks were the only one that you managed when you left. Am I right? Correct. So far?
Yep.
And then in dealing with that, you worked with the public telephone when you were at SE, but that you never managed them, right?
Right, after I left SE's.
Yes, and that you managed geothermal, electrical, the waterworks, painters, and the auctioneer associations.
Correct.
Right? And you had contracts with them?
Yes.
And that you consider an employment relationship to include both independent contractors and what other people, you consider both of those, the relationship that you had with essentially with SE when you were, we're calling it an employer, and the relationship you've had with other people, you consider those both to be employment relationships?
Yes.
Okay, and you didn't have conversations with other of these organizations regarding your taxes? Correct. Right, that you, when you talk to these other people, that you just went with what you had set up with Brenner because that's what was set up.
Correct.
Okay, and that you did not understand works to give you a choice as to the nature of your employment relationship.
Correct.
Right. And that you didn't understand anybody else to give you that choice. Correct. Right, and that your understanding was that Pat, SE was kept paying himself earlier and earlier, and that he had the power of signature, and that you went to Doug because that his payments were different than how he was being paid earlier. Is that right?
That's correct.
And that the nature of the relationship, which kind was whatever, you didn't know for sure.
Correct.
Okay, and you did, sometimes you had more than one relationship, but you not because that you didn't have enough time, but nobody told you that you couldn't have more than one.
Correct.
Okay, and that you were told that you needed to log all phone calls and keep track on a daily basis. Correct?
That is correct.
And that you don't have that because when they came to pick up stuff, they picked that up.
Correct.
Right, and that you had a calendar, just a printed out monthly calendar, and you wrote on the squares on the day what you were doing, but you didn't your hours.
Correct. I didn't put down hours.
Right, and that you wrote down your tasks that you did in connection with your job duties.
Correct.
Okay, and you were trained on web maintenance, but you don't recall any other training.
Correct.
Okay, and that nobody told you that you couldn't have other employees. Okay, and that at the convention, 60 to 125 people would come in the morning, and that your mom would help with the name tags and stuff, and before your mom or your daughter, you checked with the board prior.
Correct.
Okay, so you can go over those things, and if you have, or if you have any corrections or other things regarding the matters. And again, you know, I am learning to press all the right buttons in this situation, and I didn't catch that one quick enough in the matter. And if you want to go back on anything, Mr. Tishano, I'm not going to stop you. But I think that went over those things fairly clearly, and that's what was said. And if there's any corrections of those that you want to do, then obviously that you can do that. But I think we're that I went over and got what your cross is, I think, anyway. Okay, so
And
go ahead.
Earlier, did anyone at WWWA or any of the other associations tell you when you had to clock in or clock out for the day?
The Water Well Association asked me to answer the phone from 8 to 5, but as for clocking in or clocking out, no. Because there were a lot of times that I would be working in the evenings or on the weekends because there were things that needed to be done. So really, there wasn't specific hours. It was just that the phone had to be answered between 8 and 5.
And they didn't tell you that only you could answer the phone, correct?
No, but I don't know who else would have.
Well, when you worked at SE Consulting Group, there were multiple employees there that answered the phone, right?
Correct.
So you could have hired someone to answer the phone, correct?
No, I wasn't paid enough to have an employee.
Okay, so if you, all right, so if you had contracted for more money with them, you might have been able to pay an employee to answer the phone. Is that correct?
Maybe.
Okay. Is that why you didn't pay your mother or daughter when they worked for you?
Objection. She misstates her testimony.
No, I'm asking.
Oh.
But you're not claiming, Mr. Reinhardt, that she said that she did not pay them or consider them employees, right?
Correct.
Okay, so what is the certainly whether or not my understanding in the situation, again, my understanding is that we have established that in creation of the relationship, her state of mind is at issue. But let me just check in the matter.
I guess
hold it a second. Dealing with, I'm just going through those lists and to whether their intention. My understanding is that all the other ones are objective, what was done, not her understanding. The only one that involves, when I look at that test, the only one that involves the subjective intention of somebody involves the intention of the parties when creating the relationship, or with section that the issue as to why she did other things, I don't see in the 12 that I'm supposed to consider. Do either of you claim that's there?
Am I?
No, do either party saying that that her state of mind as to whether or not that she would pay or to what she thought in relationship to her mother or daughter has is some issue in this matter? Is either of you claiming that? Yeah.
May I respond? Objection.
Yeah.
This is David.
Yeah, I know.
My response to the objection is this, and to Your Honor's statements. In the first test under Spirides, the right to control, The fourth element is personal performance. And that goes to, and if the case makes this clear, whether or not the petitioner had the right to delegate tasks, to employ or delegate tasks to others, or whether the respondent forbade such delegation and demanded personal performance. And as such, my question goes to whether or not there was ever any written or oral instructions forbidding Bruner and Associates from having others perform these tasks. The petitioner seeks to offer into evidence this 8 to 5 telephone answering obligation as evidence under paragraph 1, or strike that, under the first part of the right to control test and the 5th part of the right to control test, meaning they seek to offer this 8 to 5 as evidence that we were telling her how to perform her work and that we were setting her hours. What I'm trying to bring to light, Commissioner, is that there was that prior to her starting Bruner and Associates, she worked for a company that managed associations that had...
Going way off the things, and you're forgetting what the question you asked was. You asked
my question
of why didn't your question was, and I remember it clearly, was why didn't she? Is that why you didn't pay them? That is not. That is not what they instructed. Is eminently apart. But I just would state in the matter, the question as asked does not go to this long argument. It just dealing with the question as asked is objectionable. The issue that you raised is clearly in the matter is whether they instructed her or did anything to her relating to. What I'm just saying is that what she was thinking at the time and her subjective intent or belief, is this test is almost completely of, what did the respondent do? What was the nature of the relationship, not what her belief about it was. So I will sustain the objection as to the question asked, while acknowledging that almost everything that you're referring to as part of your response to the objection is admissible. Just not that question. Go ahead to the next question.
Thank you. Did anyone at the WWWA forbid you from paying your mother and daughter when they worked for you at the conventions?
It was never brought up to pay them.
That's okay. Let's go on to the next question.
Did anyone at the WWWA ever forbid you from employing your mother or daughter in any capacity?
They only helped at the conference. There wasn't a situation for them to be employed.
Did they ever tell you, did anyone at the WWWA say, we don't want your mother answering the phone?
No.
Did anyone ever say, we don't want anyone else present or doing our office work or compiling minutes or helping you out with the accounting?
No.
Other than this monthly calendar where you wrote down what calls came in, and is this a calendar where each day is a square?
Correct.
And is it an 8x11 page?
Yes.
Okay.
It was in
so
I'm sorry.
So each square would be approximately 2 inches by 2 inches, correct?
Yes, probably.
Or maybe smaller, I apologize. And so in that square, you were writing maybe a task or two and a couple calls, correct?
Well, it depended. I mean, sometimes if there was a lot of calls, then it, went down into the next square. Or that binder has to be somewhere. And
okay.
if you go through the minutes, it talks about the secretary's report and the log. So it's there. It's not something that I made up. It's there.
Yes.
I just don't know where it's at.
Yes.
I just want
Other
to indicate
than-
matter. Hold it a second, Ms. Dennman. I understand no witness that I know of ever enjoys cross-examination. Please, though, your instructions are to just simply answer the questions and stop.
Okay.
You remember that you are not accused of violating anything in this case. Just so you understand, you are accusing the respondent of violating the law, and it has to do with whether they are or not. Okay.
Okay.
So in this situation, I'm not sure how you're communicating to Mr. Reinhardt, but certainly in the matter that when you through with your cross, if you want to ask him to ask you other questions, that I'll give you the opportunity to do that. But with him, that you need to answer his question and stop.
Okay. I apologize.
Your attorney will object if he thinks that's an inappropriate question. But I know it's easy to be defensive in these situations, and I ask for just to help us with just answering his questions. Go ahead.
But other than the calendar entries, were there any other written reports you made?
The secretary's report and the income and expense report.
Okay, is that it?
I guess the minutes.
All right.
That would be considered a report.
Okay. Who was your supervisor? Which member of the WWA supervised your work?
Generally, it was the president.
And that changed over the years, correct?
Correct.
And when you say when I ask you who supervised, meaning did any of these presidents have any experience in managing an association?
I don't know.
Oh, okay. So is it your testimony that some of them might have?
Well, I don't know. I know that most of them were in the association for quite a while.
Okay. I guess my question would be, when you were at SE Consulting Group, that was a company that you had a boss there, correct?
Correct.
And that boss was in the business of managing associations, correct?
Correct.
These presidents of the Water Well Association, to your knowledge, none of them had been in the business of managing associations, correct?
Correct.
Objection foundation.
He included basically to her knowledge. So she's answering based on her knowledge.
To your knowledge, what had these presidents been in the business of doing?
Well drilling.
And then, did any of them, in your experience, indicate or reference or exhibit association management skills, the likes of which you had been privy to when you were an employee at SE Consulting Group?
No.
And you testified that you worked out of your home, correct?
Correct.
Okay. And did anybody at the WWWA tell you that you couldn't have another location or that you couldn't have your office at your home?
No.
Did anyone at the WWWA express any concern about where your office was located?
When I moved from DeForest to Prairie du Chien, I went to the board and asked if I could move, and they approved that I would be able to move from DeForest to Prairie du Chien.
were you ever paid an hourly wage by any of these associations?
No.
This contract, who drafted this contract? I apologize, Judge. I'm referring to base number 302.
They're talking about the complaint 17?
Complainant 17, base number 302.
You remember that there are two 302s, so 317 is better. So do you have that exhibit, ma'am?
Yes, I have 302.
Okay, and it's complaint.
Who drafted that? I drafted it and then took it to the board and we added things to it.
What did the board add?
Different things with regards to the continuing education handbook, requesting plumbing and DNR credits, providing all registration and verification letters. Mostly things to do with continuing ed.
Meaning they added additional responsibilities of Bruner and Associates with regard to continuing education?
No, it was things that I was already doing, but they wanted in the contract.
Okay, so are you testifying that they added these items to clarify that Bruner and Associates was contractually obligated to do them, even though you'd already been performing these tasks?
Correct.
Okay, any other things that were added to the contract you drafted by the board?
Not that I recall.
Okay, and in this contract, it seems that Bruner and Associates could terminate the contract, correct?
Correct.
At any time, is that correct?
Correct.
Okay, and you did testify earlier about vacation. Did you put in this contract paid vacation?
No.
Did you mention vacation at all?
No.
Why not?
Because I guess I just didn't think about it at the time.
What about sick time? Did you put in your contract sick time?
No.
Why not?
Well, because I worked from home. If I was sick, I was already home.
Did you put in any of the contracts you've had with your associations, did you ever put vacation or sick time in your contracts to manage these associations?
No.
So the services that you provided the Water Well Association are different than the services that the members provide the public, correct?
Correct, because the members are the well drillers, if I'm understanding the question right.
Absolutely, and I apologize, it was poorly. That's absolutely the question. Meaning,
okay.
no one who's a member of the association is providing association management services to anyone else, correct?
Correct.
And so they're coming to you because of the background and experience you developed starting with your career at ESSE back in '98, correct?
Objection,
Correct.
foundation.
Somebody else's state of mind, counsel.
Okay. In this contract you drafted, there's no reference to retirement benefits, correct?
Correct.
Why?
Well, there weren't any retirement benefits. There were no benefits.
Well, you drafted the contract.
Well, objection asked and answered, argumentative. She's already testified she drafted the contract.
And so, so that she stated, okay, it has been, well, go ahead and answer. ask what you mean. So in the matter of the situation, what do you mean? What do you mean by your statement? There were no benefits.
Well, there wasn't like vacation or sick time, or there weren't any benefits.
And how was that determined?
There just never were. From the beginning, there just weren't. There wasn't any.
Okay, so my understanding is that, well, anyway, we have both a part on that she drafted it, and secondly, that she has an idea of what, that she said what she just said. Go ahead to the next question.
1 second, Judge. I'm just reviewing my notes from direct.
And you have 20 minutes to time everything perfectly for your 2 o'clock.
I have no further questions, Your Honor. Given that Your Honor has indicated that I can, if Your Honor, if I understood Your Honor correctly, that I may make reference to the deposition transcript to the extent I believe that it. Rephrase.
You're cutting in and out, but it has been received as an exhibit, so that you can refer to and talk about any contradictions or what I am to do with everything that has been received.
Then I have no further questions.
Okay. Do you have any redirect?
One follow-up question, Judge. Cindy, I just want to make it clear for the record. You said that you maintained your phone logs and your logs of daily activities somewhere while you were working for the association. Where did you keep those documents?
They were in a binder. I kept them on a calendar that I made off the computer, and they were in a binder. And
at the end of the relationship with the association, what happened to that binder?
It went with them.
Okay. And what about your secretary's correspondence or secretary's reports? Where did you keep those, if anywhere?
They would have been on the computer, or they're in the minutes.
Okay.
A lot of them are in the minutes.
And what happened to the computer where you kept the secretary's reports and the secretary's correspondence?
They took that.
Okay, those are all the questions I have.
Any recross?
Nothing, Your Honor.
Okay, then just to check in the situation, that my understanding is that we have one document that I haven't ruled on, and that is the, do you still want, my understanding is that regarding the respondent's testimony, that the responses to interrogatories are something you're saving as to that you may need or may not in response to their testimony. Is that correct?
Let me just look quick, Judge, and I'll tell you. You just give me 1 second. Judge, I don't need Exhibit 3 in.
Okay. Okay, and what about, what about complaint 6? Are you going to withdraw that, or do you want that?
I'll withdraw that, Judge.
Okay. Okay, so my understanding, and I believe then that I have ruled on your exhibits, correct?
Of complainants, yes, you have, Judge.
And so that U.S., correct?
I'm sorry, I didn't hear you, Judge.
U.S. your case?
Yes, Judge. Correct.
Okay. And then in dealing with, all right, then just the question is, are you wanting to use the, should I mark the respondents' exhibits as the depositions? Do you want those as exhibits, or do you, how are you going to use those? I'm looking for good use of the time until your break.
May I speak to that briefly, Your Honor?
Sure,
This is
yes.
Tershano. The reason I was going to call, let's start with Jennifer. The reason I was going to call Jennifer is because she is currently an employee and owner of a management entity which manages several associations throughout Wisconsin, including the Waterwell Association. And I was going to have Jennifer testify as to the nature of, in rebuttal, with regard to these such things as the title that Ms. Dennman enjoyed or her tasks. I was going to offer evidence from her as to how her contractual relationship and the most, as to how her contractual relationship is with the WWWA and with other associations. So essentially, to rebut the presumption of employment by the title executive director.
I would
then,
not understand. I mean, I just was saying that, so far I don't, when I look at the description of the case law or what I'm to look at, conspicuously absent from the, certainly we're not as though the right to control will have anything to do with the title. And in the situation of the 11 additional factors, I see nothing regarding title in any of those.
the second element of her testimony would have been in rebuttal to the assertion that the purchase of the laptop or the desk might be in and of itself exhaustive or evidence of control, because I would have her testify that it's common in the contract she has with associations to have the association pick up expenses for specific pieces of equipment.
Well, the question, and dealing with, and the extent to which my understanding is that you're, what I'm understanding that I'm doing, and as far as this situation, the evidence as to what it looks like when things are more clearly employment. My understanding is I got a pretty good idea as to, and the things as to that. I understand that what I'm having to do here is figure out where the line is when there's some elements of, employment and some elements of independent contractor about where the heck the line is. Because I think that this case challenges, it has aspects of both. And so I am not so far in this description. And again, if you wanted, I'm not seeing so much about how those things, let me just, what I'm seeing is that this, and one of the things that I noticed that you kindly provided is that the referred to is that the right of that the control is that there are other aspects of that which are not in this decision, correct, legally? You have referred to a variety of elements of the right to control, and my understanding is this case does not recite them, correct?
Correct.
So my understanding is that what I'm doing in this case is looking at that case law as to, you've referred to 4 elements as far as I can remember. Is that right?
Yes, I referred to 11 in the punch list, as I call it, the additional factors, and I referred to 3 of the elements in the biggie, which is the right to control.
And the right control has elements to it?
It has 6.
6. Okay, goody. Then I have, all right. So my understanding is I got 17 things to consider. Okay. And then I have the wonderful opportunity to figure out, okay, now if they go somewhere it goes this way and somewhere it goes that, where the heck the line is. So my understanding is that I'm looking completely at the factually established nature of the relationship, and then looking and given this factual basis for the relationship, trying to figure out where the line is. Is that, I mean, do either of you view that my task in this case to be something different than that?
Reinhardt doesn't.
Neither does the respondent.
Okay, so understanding is that what other people think of that part that I have, if it doesn't go to concretely, we have, different elements in these situations and I have the statute. So if it doesn't go to any factual dispute regarding what the parties did with each other, opinions by some person as to whether something is common in a certain business or not doesn't appear to me very helpful unless I'm mistaken.
No, I understand completely, and that's why I brought it up, so I could circumvent wasting the court's time and irritating the commissioner.
My irritation, my understanding is not one of the 17 factors. And so if it is not shown as something I can consider, it's not a consideration. So, the question is, do you want to the extent that you were to use these things, should I mark those depositions as exhibits and just use those? Do you not use them at all? What do I do regarding these other participants? Or you want to think about it while you go and deal with your thing and be back in, hopefully 15 minutes, half hour from here. What do you want to do with these things? It's 1:45 now. Talk to them sooner, or is it right at 2:00?
It would be right at 2:00. It's Milwaukee's room 409, Milwaukee Court, and I could think about it in the next 15 minutes as to. Well, I guess it's really up to Mr. Reinhardt if he wants to offer those deposition transcripts into evidence. That's his decision. I don't think I need to. I don't have any objection to offering them into evidence. And then I guess the question would be whether or not. I guess the only issue I have about calling them as witnesses was I wanted to make sure that the rest of my exhibits were entered, but they are entered into evidence and I can reference them in my post-hearing brief. So I guess I have nothing left. I'm not going to call any witnesses given that I can reference given that I can reference all of these exhibits in my brief.
Okay, all right. Then the situation is then, Mr. Reinhardt, do you want any of those depositions in the record?
Well, Judge, I'm not clear if Attorney Terciano is saying he's not going to call those people.
That's what he just said.
Okay, David? Is that what you said?
Yes.
Okay.
Okay, we lost Mr. Reinhardt.
I don't know the answer to that, Judge. Can you give me 2 minutes to decide?
Sure. And dealing with, I'll go off the, I'll pause.
Judge?
You ready?
Yeah. I mean, if Attorney Terciano has no objection, I'd offer them as exhibits.
Okay, then I will mark, and they will be, and then there'd be as, since you are offering them, let me just get to the, I will mark them as
this would be 18, Judge?
18, 19, and 20, because there's 3 of them, right?
There's 4 of them.
Okay, and then okay, and you want as 18 as 18?
I would just go consecutively, Judge. I believe the first deposition is Crow, and I believe that starts at ERD 380, so that would be 18.
Okay. And dealing with the what's the name again?
It is Crow. It is Dennis Crow, CROW.
Okay, and 19 starts at when?
C19 starts at 395, and that is Gary Kuhn, Kuhn.
Excuse me?
Yeah?
Oh, I'm sorry. I apologize.
Gary Kuhn and Kuhn?
Kuhn, Judge.
Kuhn. And okay, and you know that's
19.
And
20 starts at 410, ERD 410, and that's Terry Marshall. Terry, Terry, Marshall, Marshall.
Okay, and 21 starts at when?
At 21 starts at 423, and that is Richard Peterson, Peterson.
Okay, and all right, then those are received into evidence. And then that my understanding is that since the respondent hasn't put any additional evidence, that there would be no basis for rebuttal testimony, right?
Correct, Judge.
Okay, and so both of you are correct?
Yes, Judge.
Yes, Judge.
Okay, and so then my understanding of 45 days for the I actually in the matter will give you in the matter the response to add 15 days for rebuttal. I am not the extent to which that you both are had feedback of the other's interpretation of the statute. I'm going to add 15 days for rebuttal to the things because you don't have to, but when we're dealing with something which I haven't dealt with this much, and it is so much of a we have a defined legal standard, and we have this record, including a particular issue regarding, okay, if we have some things in the statute and a particular thing, at what point does it become covered when it's partway? That's among the questions, because that I would like to understand your opinion about it, because I hopefully that both of you can understand that there are some elements that are in favor of the other one's point of view.
Understood.
And, you know, this.
Judge, not only, this is from Tershano, I don't mean to interrupt. When I read through Spirides, it becomes difficult to argue that I'm not an employee of one of my largest clients, meaning I have a subprime auto lender who uses me for bankruptcy work in 3 states, and they have so many policies and procedures and reports, and they keep track of everything that I do. So I totally understand your point, Judge.
Anyway, so I just want to dealing with it because there's going to be things that the question is, okay, how do I tell at what point these factors get so the thing is, and so that's why I'm saying, you know, I want to give you 15 days to rebut what the other one's saying, so I have a little bit more of a, you know, dialogue, or, you know, so you can clarify this to me the extent that you know, they can, as far as, you know, for to try to be clearer on this. Anyway, that with that, and I note I've been watching that time, and I note that not only did you manage to get to a break before 2 o'clock, but you actually resulting that well finishing before 2 o'clock. So anyway, I just believe in giving credit where credit's due. That's all. So is there anything else we need to attend to before closing the record?
Judge, would you just send us the dates? I haven't checked if they fall on a weekend or not. The 45 days.
You can just, if you two agree on as far as what it's due, if it's 46 or something, the two agree where that is and when to exchange it, that's fine. You two, my understanding of, are able to talk to each other without, you know, civilly, and so, you know, let me know what you agreed to. Is that all right? You know, who I am.
Is that in the mail, Judge, or is it emailed, or how?
Email's fine.
So email it by that date. Okay.
Yeah, I mean, dealing with the.
Peter, just send me an email and with your proposed, you know, where you want the first one due and what you think the second one would be due. Right.
Okay.
All right. So thank you both, and you got to get to your thing. Can't let the courts wait. Anyway, thank you both for engaging in. The successfully survived hearing number 2.
Thanks, Judge. Take care.
Judge.
Take care. Bye.
All right. Bye-bye.
Now we're going. That in dealing with I called the case of Cynthia Dennman versus Wisconsin Water Well Association. This is ERD case number CR 2017-03222. And Ms. Dennman, are you still on Millville Hollow Road in Mount Hope?
Yes, I am.
Okay, and is still the West Washington Street address still the correct number for address for Wisconsin Water Well Association?
Yes. Judge.
Okay. All right. This is a hearing on a remand from the Labor and Industry Review Commission, and just dealing with reminding us regarding what that is and the circumstances that in referring to the remand, and I'm just going to that. It refers to the Spirides versus Reinhardt. Anyway, there's just to let you know, Mr. Reinhardt, that, you know, you're defendant in that case, in the matter. Anyway, it states that we're supposed to look at that the extent of employers' right to control the means and manner of the workers' performance. Factor to review here, and additional factors include the type of occupation, with reference to whether the work usually is done under the direction of a supervisor or done by a specialist without supervision, the skill required in the particular operation, whether the employer or individual in question furnishes the employment used, and the place of work, the length of time during which the individual has worked, the method of payment, whether by time or by the job, the manner in which the work relationship is terminated, the annual leave, whether annual leave is afforded, whether the work is an integral part of the business of the employer, whether the worker accumulates retirement benefits, whether the employer pays Social Security, taxes, and the intention of the parties. And so that that I was instructed in the manner that they reversed my decision of dismissal and said that I must consider, let me just trying to get the, it says the commission finds that the analysis in OMEGBU, OMEGBU to be instructive. It supports the conclusion that the determination of whether the complainant was an employer or an independent contractor requires more than a simple inquiry into whether the complainant performs her services for a corporation, whether all of the economic relationships of the realities of the relationship must be considered and that test applied. So have the parties parties agree that that is the basis for this hearing and for this this hearing at this point.
Yes, Judge, with a clarification, and maybe I'm off on this, but you're really making it's really a probable cause determination on that issue, isn't it?
My understanding is that I make a determination under the, it's a good question, but I would state it this way, that my understanding, and this is something that I in my thinking, the parties can argue exactly how this is set up. Clearly that I am dealing with the remand of the commission and making the determination that the commission told me to, first of all. My understanding is that they are saying I am to make that determination. To me, it sounds as though that on one hand, if I determine that it's an independent contractor, that's not a probable cause decision, and that it is, well, my understanding is it's a final decision on that question. So okay. It isn't a decision. We've had a variety of other cases in which there's been a decision like this that has gone forward in some manner. My understanding is that if I determine that they are not covered, that is a final decision for appeal. If I determine that they are covered, that is a final decision for appeal after the matter, and it is not something that the ALJ that would hear any merits or, on the merits of the claim would revisit until there was appeal to the commission or somebody above. It is the ALJ level determination on that issue, which will not be revisited by another ALJ. Okay. Does that answer your question?
Thank you for your clarification. Yes, it does.
And do either of you view that? I mean, my understanding is the final decision, and it isn't whether it's probable or not. It is a determination on that question. I am to apply that test in a final manner, and that the only appeal to that is to the commission and on the matter. Do either of you view that my authority or this decision is any different than I have articulated?
Tershano here, no. That's the way I read the remand.
Okay. So, and dealing with the, so I'm to make a determination and, to go forward and just to check on the situation. This certainly is a matter that sort of begs argument. Do either of you know at this point that you want to file a brief in this matter?
Reinhardt would like to, and I would suggest that we have simultaneous briefs, no response and reply.
That's my starting point. And is enough, or you need more than that?
Reinhardt needs more than that.
How much?
We have 45 days.
Okay. Any problem with that? Does that work for you?
That's fine, Judge.
Okay. And dealing within the matter. So, and my understanding is that certainly that the issue has been spelled out or articulated by the commission, and so as to what it is, and I would urge that you respond to the commission's articulation, because obviously in my decision I will need to. Okay, so then in the question, in the matter that Mr. Reinhardt has stated that his understanding that most of these exhibits in the situation are, other than complaints exhibit 3, are ones that there don't seem to be a whole lot of dispute about, and there may be agreement as to intermission or not. And so just to check in dealing with this in the matter, is there the complaints exhibit number 1 is the let's see if we have is the business card. Mr. And could you pronounce your last name, counsel, again, so I can try to get as close as I can to it? Terciano?
Yeah, Terciano.
Terciano. Okay, not this. I'm giving it an extra syllable, and I need to not do that. Mr. Terciano, do you have any that regarding complaints exhibit 1? Do you have any issue with foundation on that?
You know, Commissioner, counsel and I discussed this yesterday, and I told him that we could address it this morning. If this helps, I've reviewed these exhibits, and I have no problem stipulating to the reception of these exhibits by the court as listed. I only reserve the right to object to reception of exhibits off for impeachment or rebuttals, just such that I could review them. But the ones that are detailed in their exhibit list, I'll stipulate to their having been to their reception by the court, as long as the court wants to receive them.
Well, if the parties ask it and you don't have any objection, then my wants is not of a particular concern here. So my understanding, but I still want to go through them, and this may not be long, but just to check on these matters and make sure you got there's no question regarding the Bates numbers situation. So I'll view that there's a stipulation to foundation and receipt of complaints exhibit 1, which is just number 1. Complaints exhibit 2 is Bates stamp numbers 2 through 11. Is that right? Any issue with that? I mean, just dealing with that's 2 through 11. I mean, if there is, and going through this, if you haven't found any discrepancies on those things when I'm going through, then it's you need to let me know now. Otherwise, I'm just going to assume that these are my numbering that I've sent you is correct. So complaints exhibit 2, I mean the quick reports, and it's 2 through 11. Any issue with that or any issue with receipt?